Hello and welcome to Liberty and Gun Rights Podcast. Today's date is Thursday, September the 14th, 2023. Thank you for joining with us. Today I have a guest speaker by the name of Robert Merting, and I'm going to allow him to introduce himself and tell us Robert, tell us who you are and what do you do for a living and all that good stuff.
James, thank you for having me on tonight. I'm an attorney in South Carolina, and my practice focuses around firearms law. So I spent a good bit of time analyzing federal, state, South Carolina state law, how it interacts with people's firearm rights, and what I can do to help them restore rights, to show that they have things correct, get CWPs issued, just all types of things of that nature.
I got you. Okay. Can you tell us about some people? Do you have any examples of people that face challenges with regards to getting their lawful legal gun owners, and they go to get their South Carolina CWP, and all of a sudden the SLED denies them for whatever various reasons? Can you have any examples of that and how to fix it?
I'll keep things on the hypothetical or on the generic, but certainly have seen many problems. In South Carolina, we're one of the shell issue states, so you'll see counted by all the major gun rights organizations. The reality is we're actually a may issue state, and that may falls into the hands of the sheriff. So the statute says that SLED shall consider the recommendation of the sheriff. SLED takes that shall consider to mean shall follow. And if the sheriff says yay or nay, as long as it's a legal action, i.e. the person's not prohibited, then SLED's going to follow. And what I have seen is that some sheriffs take no stance whatsoever, but other sheriffs will take a stance of looking at a person, and if they don't like something they see, saying no. And that gives the sheriff pure autonomy to do whatever he wishes. And SLED's not, going to bat necessarily and ignoring the sheriff when he has a bad reason, though they will reach out and try to talk to the sheriff to see if they can better explain something.
Okay, I got you. I'm sure it's a very, very frustrating experience for legal gun owners, people in South Carolina who they go to a gun store and they fill out, what is that, the 4473 or 4773? I forget the exact number. You have to fill out a form, and the gun store, the salesman, whoever, they punch it into a computer, or they pick up the phone and they'll call whoever it is they call, and they do a quick cursory FBI background check, and sometimes they'll have to wait on a return phone call, or they'll get a form back on the computer saying either yay or nay. And so you have people that are able to go to a gun store and buy a firearm, and then they go out and try to get their CWP, and all of a sudden they get rejected. So it kind of sends mixed signals.
It absolutely does. I've certainly seen clients. One of my favorite memories on one of these is I had a client that went through the background check at a local store, was approved, took the gun home. About 45 days later, the ATF shows up at his door and tells him that they have reviewed his background check. He now is not approved, and he has to take that gun back to the store. He takes the gun back to the store. He's not looking for a fight with the ATF. He gives me a call, we discuss, and he tells me that he has a CWP application in the works. And we figure that CWP application is going to be rejected. We identify the problem and go to work on it. And when he comes to meet me, he brings with his CWP. So these background checks don't line up. And that's something that you have to remember, is just because you passed one does not necessarily mean you're going to pass the next one, or just because you failed one does not mean you're necessarily going to fail the next one. What you have to realize and look at is what's actually on your record. So, for instance, some of the things that I will see is charges. If you get a criminal charge, even though it may not have been brought to fruition, it may not be a conviction, if it's just hanging out there as just an arrest, that can be interpreted multiple ways. Some of the examiners looking at that may say they don't know what's going on. And in a CWP application, they may deny it because they want to know what actually happened with that arrest. Was it a conviction? Was it not? In a purchase, though, typically the law says that if they can't show you're prohibited, then they have to approve. So even though they may know that arrest exists, they may know there's a question there, they have to let it go through after a delayed amount of time to research it. So a improperly recorded arrest without any disposition is a classic reason people get denied on CWP.
Right, I hear you. I actually had a situation where I work for a security firm, and on a part-time job, and once a year I have to go to a course and get recertified. And of course, they send your application back to SLED to get your card renewed, and so you can legally work for the company as a security officer in South Carolina. And my very first one got denied because of a charge 41 years ago in Texas, where I got arrested. It was a felony arrest, but it was a no bill. In other words, the grand jury did not decide to indict on the charge because basically there wasn't anything there. I didn't do it, and so they passed. They gave me a no bill, and but nobody ever, the DA's office and the prosecutor, nobody bothered to put what happened on the record. They didn't, like you said, they didn't show a disposition. So once I got the court record, from that jurisdiction and submitted that to SLED, they said, "Oh, okay. Well, we see what happened. You were arrested, but you weren't convicted, so therefore you can continue to work for this security company." So it was a pain.
That's a very classic story. You're actually lucky that 40 some years later they still had records of a no bill or non-conviction. Many times what I have found is that the courts, after 10, 15 years non-conviction, that's completely unimportant, and they're throwing those things away. And you wind up having to go to SLED and documenting that you've looked at every single court that could have potentially handled this charge, and every one of them have verified for you that they have no records for this person. They have no records for this charge. They have no records for these numbers. And just submit to SLED that there is no record. And of course, the only way there'd be no record if there was no conviction. Typically, SLED will go with that if you can actually get those statements. But certainly I have spent some time chasing things down 40, 50 years old, and having to go really long and hard to find statements of nothing.
Yeah, that causes a lot of inconvenience and extra cost for the people that are using your legal services to fight for their Second Amendment rights and their liberty and their ability to protect themselves and their family members.
It definitely is frustration. It's definitely cost. Sometimes there's absolutely no reason for what that person did to even be in that situation. I've had cases where it's mistaken identity. And sometimes you can figure out where that mistake came from. Sometimes it's so deeply buried, all you get back is a note from the agency of, we made a mistake and it's been corrected. And, because of somebody else's privacy, they're not going to tell you how the mistake got made. So you see these, and they are, as you say, angst and headaches and cost. And it can take time, and time is money, to go back and show that there is no record, or to go back and actually find that record. I have seen those at 45, 50 years later. You'll find where a charge that was brought as a felony got pled down to a misdemeanor, and it only became important in the last 5 or 6 years, and you got to go find that conviction record to show how it was pled down, and it makes all the difference in the world for that client's gun rights.
So let's talk about some other reasons or causes that would prohibit somebody from getting their CWP. I think one of the things that comes to mind is domestic disputes, restraining orders, anything to do with the domestic problems that winds up in the courts or on somebody's record. If you were talking to people that are trying to get their CWP, what are some of the red flags that they need to be aware of to make sure that those things don't happen?
Good question and good timing. I actually had to look at a case like that today, where just trying to understand, did the person lose their gun rights? And it sounds really straightforward question, but you get into it at times and it's very confusing. For instance, in this situation, we had a restraining order. And the restraining order, we believe, is no longer valid. Typically, they're issued for 1 year and they expire. We have a violation on that restraining order. Well, that violation of the restraining order, more than likely, involves somebody who would fit the category of an intimate partner, meaning a spouse, someone they share a child with, someone they cohabitated with. So now the question becomes not what the title of the crime is, but whether the crime has the elements that meet the definition of a crime of domestic violence. So the crime of domestic violence is actually a term of art defined by the federal statutes. And the federal statute doesn't depend upon the state law to name their crime, meeting the federal name. What it depends upon is certain elements being in there. Those elements are a relationship of the parties, and then that it contains a actual physical force or the threat of deadly force. So a threat to shoot, a threat to run somebody over, that would be enough to satisfy one of the elements. What would also satisfy the element is that physical force. And that could be just a mere touch, which means even the most minor misdemeanor, if it's a spouse, a person who cohabitated with you as a spouse, a person you share a child in common with, a child, if those are the victims, then out the window goes gun rights, even if it is a assault and battery. I've even seen that question come up for something like a disorderly conduct.
Right. Well, it's crazy. So liberty and gun rights is, I guess there's a delicate balance there. You know, things can happen in life. You know, life happens and things happen, and people get into heated arguments, and you know, husbands and wives argue, and boyfriends and girlfriends argue, and if you're not thinking with a cool head or thinking clearly, you can wind up, you know, destroying your gun rights and not even know it, not even understand that what you're doing or what you're getting involved in is going to prohibit you from getting a firearm.
Many times the story I hear from clients is it was 1990s. Sometimes it's before this prohibition came into effect in the 93, 94 time period, so late 80s, early 90s. And it was a misdemeanor. It was a $50 fine. Why go fight it? Why go through the trouble? Just here's $50, y'all pound sand. Well, now fast forward 30 years, you want gun rights back, and you're going to have to deal with that $50. And going forward, not retroactively now, but going forward after June of last year, we have a boyfriend-girlfriend prohibition. If you're a dating person, and then they come up with ideas, what does it mean to be a dating partner? And you commit crime against that dating partner as a misdemeanor, that can prohibit you. That prohibitor, unlike almost all the other federal prohibitors, does have a potential expiration date. I say potential because if you get other convictions of that nature, then you're not going to have it expire. But if you get just that one and time passes and you're no longer with that person, then it can pass off.
Okay, very interesting. What about somebody winding up on some kind of a list? Let's say they're not, quote unquote, a felon, or they may not even have a felony arrest, but because of associating with the wrong people or running with the wrong crowd. I mean, I don't know. Could somebody wind up on a domestic terrorist list and not know it, and then all of a sudden they're trying to get a CWP or trying to buy a firearm, and they SLED gets or the FBI gets wind of it, and then all of a sudden you're denied. Have you seen anything like that?
I have not seen a person entered into the list purposefully without any record behind it. So I've seen persons that have mistakenly been entered, and once the mistaken identity is figured out, they come off the list. Presumably there was a record for somebody else behind that. I have seen people who have been entered on the list for various records, including mental commitments and adjudications. We could certainly talk about those. There are a few cases that have made the news about people voluntarily agreeing to be put on the list as some way to settle a dispute with the FBI or the ATF. That's under some legal challenges right now, whether or not that's even legal. because there's no provision in federal law that a prohibited person is somebody who agrees to be a prohibited person. They all have to meet one of 8 or 9 categories, and there's typically a reason for it. The closest I would see for somebody having no knowledge of it is a person that is a fugitive from justice. And a fugitive from justice might be as simple as somebody who has a driving ticket or a parking violation, doesn't necessarily know it and fails to pay it. And those cases have come up, though I, to be honest, have not seen one personally, so they're fairly rare.
All right. What about state law versus federal law? I mean, when they run your FBI background check when you're trying to buy a weapon, a firearm at a gun store, could you be afoul of some sort of federal law, uh, but not necessarily a state law that could get you denied for purchasing a firearm?
Certainly. In South Carolina, we have fewer prohibitions than they do federally. We share a prohibition generally of felons not being able to own and possess firearms. We have a prohibition for domestic violence, and people committed of it can't own and possess firearms. That prohibition actually has a sunset period on it, and it's tiered 3, 5, 10 years, depending on what crime you commit. And then we have mental adjudications. We have a prohibition for mental adjudications. We do have a old statute, probably goes back to the 60s or before that a court can find somebody to be a prohibited person. I've never actually seen it used outside of the mental adjudication route. What we don't have is a general prohibition on high-level misdemeanors. So the federal government doesn't actually have a law that says felons can't own guns. Everybody thinks that, but that's not what the law says. The law says that a person convicted of a crime that can be punished by more than 1 year in prison. Not is punished, but could be punished. That is then defined as a term of art to mean a crime that is punishable by more than 1 year in prison, or in the case of a state misdemeanor, a crime punishable by more than 2 years in prison. So it is possible to have a felony in South Carolina that's not punished by more than 1 year in prison, and you could be convicted of a felony and still able to own guns federally. And it's very common to find that we have some 3-year misdemeanors that if you get convicted of, you lose your federal gun rights, but there's nothing at the state level which they can charge you for. You can still own and possess a gun as at the state level. So it creates this odd situation where if you're pulled over, stopped by the police, they can't charge you, but they will turn it into the ATF to see if the ATF wants to charge you.
Very interesting. So one of the things that I tell people, and I encourage people that once they get their CWP, and I encourage them to train with it. It's not a magical talisman that, oh, I've got my CWP, I've bought a firearm, I've fired 30 rounds at the range to qualify. Now I'm going to take it home, I'm going to stick it in my nightstand, and all of a sudden it's magical and nothing bad can ever happen to you, right? One of the other things, we know that that's a fallacy, and we encourage people to get as much training as possible on a regular basis. And the other thing we do is I encourage people to get self-defense insurance like USCCA, US Law Shield, things like that, because a lot of people don't consider what awaits them. Let's just say, God forbid, you're in a self-defense scenario. You're walking across the parking lot. You just come out of the restaurant, let's say, with your family, and you walk across the parking lot, and all of a sudden, a couple of thugs want to attack y'all, and get your money, and carjacking or whatever the scenario is, and you're in fear of serious bodily injury and or death, and so you have the right and ability to use deadly force, and so the smoke clears, the cops are there. You're going to probably wind up in handcuffs and go to jail for the night until your attorney can get you out of jail. But people need to be aware of, it's very, very important. Just like you have a doctor, a general practitioner, you have specialists as you grow older. You have different things that the check engine light comes on. you probably don't, as young as you are, you probably don't realize this is coming, but uh, we need specialists in our corner that can advocate for us and that can educate us and tell us, a plan of action. And so I always like I have an attorney in Mount Pleasant that's he's a criminal attorney, and he's also a supporter of the Second Amendment, and he's versed in South Carolina gun laws. So I got him on speed dial, and he's got me in his contact list. If something were to happen, he would be the first person I would call after 911. So can you speak to the importance of South Carolina gun owners and CWP holders uh, thinking about that, and thinking about the importance of having legal counsel available to, come alongside and tell them, what to say, what not to say, to shut up, don't talk to the police, whatever those things might be.
James, I have a whole hour-long presentation that I can do on that, and love to do it. It's a great one to do interactively. What I'll say today is kind of to back you up and tell people they need to think about that. So you mentioned you get your CWP, and we encourage gun owners to go out there and train. And that's because the use of a firearm is a deteriorating skill set that you have to constantly practice on. And if you practice with training and you get out there and you shoot your gun, one of the things you're going to hear is muscle memory. And muscle memory is the idea that if you do something the same way enough times in a row practicing it, that your muscles will pick that up. And when your brain's not fully functioning, when you're on autopilot, your muscles are going to do this, and they're going to do it automatically, and that's going to pull you through a situation. It's going to produce repeatability. So I want you to think with me here for a moment. I have one of the most ubiquitous items that probably all of us have within a few inches of us, and that's the cell phone. What is your muscle memory when you take the cell phone and you put it right here? What happens when you do that?
You talk, or
you talk,
or you listen.
When you call 911, they start asking you questions about, well, what happened? Where are you? Does he have a firearm? Do you have a firearm? Where are the police going to come? Is there a safe place you can go? What did you do? You're going to want to answer it because your muscle memory tells you, I need to talk. And if you're not trained for that, you're just going to be putty in the hands of the 911 caller. You're going to answer all those questions that will come in as evidence and are going to solidify your situation before you've actually had time to digest it, understand it, and really know what happened.
Yeah, those 911 calls are they're digitally recorded, and they can and will be used in a court of law, whether you like it or not. So yeah, you're correct. It's something that we need to prepare for before that sort of thing happens. You need to have a relationship with an attorney, and you need to sit down and talk with them. And like USCCA, they have an instruction card, their membership card that you get in the mail. On the back of it, it tells you what to say. Call 911. Hey, I'm the victim. Please send an ambulance. Somebody's been hurt. You need to establish that you're the victim. When you first call them, and I'm sure you can speak to that. A lot more detail, and we don't need to cover that necessarily on this podcast, but I would certainly like to have a more in-depth conversation about that on another episode.
Be very happy to get into that, and then we can discuss about who to call first, when to make the call, what things to be able to say, what things not to say. What does it mean to be able to hire counsel versus public defender? Do you want to hire experts? Do you want to hire an investigator? There's a lot of things that can go into having to defend one of those cases, and if you're being charged with murder, your life is on the line. So we don't want to do a half defense. We want to give it our best.
Right, and legal defense is not free. It can be quite expensive, which is one of the reasons why you want a self-defense policy with one of these organizations, because they provide you a certain level of they can help you with bonding out of jail, get you out of jail for the night, and so that your legal team or your attorney or whoever can start working on your case and prepare an effective defense for you.
There's a lot that can go into it. It's certainly nice to not be thinking about where the money's going to come from.
Right, absolutely. All right. Well, we're working on about 25 minutes here, which is not bad. Most podcasts take from 15 to say 30 to 40 minutes, and so this has been a very interesting conversation, and I appreciate you taking the time out of your day to be a guest speaker, and I look forward to you sharing more knowledge with our listeners.
James, very much glad to have me on, and very much glad to be here, and be very happy to come back.
All right, so thank you for the privilege of your time, both you, Robert, and the listeners. Our podcast is hosted on Amazon Music, iHeartRadio, and Spotify. Be sure to share our podcast with your Second Amendment friends, family, and coworkers. You can contact us at Liberty Gun Rights Podcast at proton.me. That's Liberty Gun Rights Podcast at proton.me. Thank you for listening to today's episode, and goodbye for now.